Whenever possible.
ये अलग कर लो yours. Date. ठीक है first. Keep that out because he may refer to some other pen. May I?
Yes, Mr.
Well, let me just complete the reading of Shivraj because there were 4 or 5 paras left, and then I'll go on to the timelines and the issues referred to your lordships.
So that is page.
Para 78, my lords, I know I read it yesterday, but just for the sake of
para judgment compilation 2.
Yes. PDF page.
Volume 1.
PDF 1388. Volume 1.
Volume 1.
Yes.
Oh.
Volume 1. Compilation is serial number 2. This is volume 1 of that judgment.
Judgment compilation 1, right?
Yes, Shivraj Singh.
Volume 1.
PDF page?
1388.
1388. 1388.
Yes.
The idea underlying the trust vote in the ultimate analysis is to uphold the political.
70. Looking for the right para. Just give me.
I did, my lords. I just want to read it again because it gives a continuity to the next 3 paragraphs.
Number 2, serial number 2. Status. Thank you.
Taciturn.
Yes.
The idea underlying the trust vote in the ultimate analysis is to uphold the political accountability of the elected government to the state legislature. Assertion of accountability is a mirror image of the collective responsibility of the government to the legislature. The requirement of the trust vote fulfills that purpose in the present case. The present controversy has shone a light on the often fluid allegiances of democratically elected representatives. This is a matter for their conscience, and the court expresses no opinion on the matter. However, it is important to note that in directing a trust vote, the governor does not favor a particular political party. It is inevitable that the specific timing of a trust vote may tilt the balance towards the party possessing a majority at the time the trust vote is directed. All the political parties are equally at risk of losing the support of their elected legislatures, just as the legislators are at the risk of losing the vote of the electorate. This is how the system of parliamentary governance operates, and the learned senior counsel on both sides of the dispute congenially admitted that the outcome of the trust vote is the ultimate litmus test for the legitimacy to govern. However, we note that where the evidence indicates that circumstances of violence and coercion exist that would undermine a free and fair vote in the assembly, the governor and the court must take measures to ensure that the sanctity of the trust vote is maintained. In the circumstances as they have emerged in this case, the exercise of the authority by the governor was based on circumstances which were legitimate to the purpose of ensuring that the norm of collective responsibility is duly preserved. There existed no extraordinary circumstances for the governor to determine the trust vote was not the appropriate course of action on 16/3/2020. A significant ground of attack by Dr. Singhvi, learned senior counsel appearing on behalf of the speaker, on the decision by the governor to call for the trust vote is that convening a trust vote at this stage will impinge on the discretion of the Speaker to determine whether the resignation should be accepted under proviso to Section 190, subclause 3, subclause B, and at the second level, to decide upon the consequences of the resignation in terms of anti-defection provisions of the 10th schedule. Short-circuiting is the phrase which was used by Dr. Singhvi. Implicit in the submission is the charge that holding a trust vote impinges upon the discretion of the Speaker on whether to accept the resignations and to decide whether these members have incurred the wrath of disqualification. While analyzing the submissions articulated by Dr. Singhvi, the cobwebs need to be cleared. Governor does not decide whether the resignations that were submitted by the members were genuine and voluntary. That is squarely a matter which lies within the domain of the Speaker. Similarly, whether a member of the House has incurred disqualification under the 10th schedule is a matter where the Speaker is the designated authority. Conscious as the court has been of the fact that these are matters which lie within the domain of the Speaker, in the recent past, a direction to the members to appear before the Speaker and for the Speaker to take a decision immediately was recalled by a 3-judge bench. Dr. Singhvi alluded to these orders. It is strike law that neither the governor nor for that matter this court has the power to impinge upon the authority of the Speaker to take a decision on the above issues. The issue, however, is whether the convening of a trust vote has to be deferred until such time as the Speaker has taken a decision on whether or not to accept the resignations, and if so, the consequence of the members departing from the fold of the party on whose ticket they were elected under the 10th schedule. Holding of a trust vote operates in a distinct field from the issue as to whether one or more individual member of the Legislative Assembly have embarked upon a voluntary act of resignation or have incurred the wrath of 10th schedule. Holding a trust vote is necessary to ascertain whether the Council of Ministers, headed by the Chief Minister, has the confidence of the House. The continuous existence of the confidence is crucial to the legitimacy and hence survival of the government. It is a matter which can brook no delay, since the authority of the government presided over by the Chief Minister depends on the Council of Ministers continuing to have faith of the legislative body as a collective entity, particularly where the members resigned in an expression of the lack of faith in the existing government. The convening of a floor test is the surest method of assessing the impact of resignation on the collective will of the House. The consequence of acceptance of resignation is to reduce the numerical strength of the House. Until the resignations are accepted, the members who have resigned continue to be reflected in the strength of the House, having regard to the language which has been employed in Article 190, subclause 3, subclause B, shall thereupon fall vacant. Whether in a situation such as the present, an elected government is entitled to continue despite the resignations of 22 of its members has a significant bearing on the issue of confidence. Neither the governor nor for that matter the court can entrench upon the power of the Speaker, but the pendency of the proceedings before the Speaker cannot be a valid basis to not have the confidence of the House in the government determined by the convening of a floor test. Added to this is the factual circumstance in the present case that the Speaker accepted the resignations tendered by 6 of the 22 members on 14/3/20. All of the members sailed together. No explanation was forthcoming in the submission of Dr. Singhvi on what, if any, was the distinction between 6 members whose resignation were accepted with alacrity and the remaining 16 on whose resignations no decision has been taken. None of the members who resigned, neither the 6 or the 16, appeared before the Speaker. Therefore, non-appearance before the Speaker is evidently not a ground of distinction. We have highlighted the above factual scenario only to emphasize that the convening of a trust vote is of crucial importance to affirm the fundamental values of the Constitution, namely abiding by the rules which govern a parliamentary democracy. The fundamental precept of parliamentary democracy is that the government owes collective responsibility to the Legislative Assembly, and as a collective body, the Legislative Assembly is entitled to hold the government to account. The ultimate expression of accountability is the existence of or lack of confidence in the Council of Ministers. We are therefore unable to accept the submission of Dr. Singhvi that the holding of a trust vote would short-circuit the jurisdiction of the Speaker on a matter of resignation and disqualification. My lords, I just halt here for a minute. Your lordships dealt...
Before that, read para 82 also.
82, yes. During the course of his submission, Dr. Singhvi fairly accepted that the holding of a trust vote at this stage would ultimately only affect the ability of the resigning members to accept ministerial office in a new government, and that may be formed if the issue of disqualification has not been addressed in the meantime. Dr. Singhvi submitted that the effort in such cases is for resigning members to bring down a government on the allure of ministerial positions in a succeeding government, as the disqualification may not be accepted in future if the government were to change. This, as Dr. Singhvi submitted before the court, is how democratic politics operates in reality. The point of the matter, however, is that nothing prevents the Speaker from taking a decision either on matters of resignation or disqualification despite convening of a trust vote. That Speaker has not yet done so is not a ground to defer the convening of a trust vote. Now, my respectful submission is that these two submissions are not being made for the first time before your lordship, that immediately when the government is formed, a trust vote should only be held then and not later, and that if there is a disqualification pending, there should be no trust vote. These two submissions and arguments were categorically taken in Shivraj Singh Chauhan and categorically rejected in there. Because, my lords, ultimately, please see who are we dealing with in this matter. We are dealing with three distinct constitutional authorities. We are dealing with the Speaker, who exercises and is the sole authority to exercise jurisdiction under the 10th schedule. We are dealing with the Governor, who's the sole authority to decide whether there should be a floor test or not. And we are dealing with the Election Commission, which under the symbols order, read with Article 324, is the sole authority to decide whether within a political party, a rival faction or a splinter group, as they say, has emerged or not. Now, repeatedly saying that there has been a split and you have not merged is of no consequence, because that is no one's case. I have never argued that I have split from the political party. We have never argued that we needed to merge with another parties. Those were defenses under the 10th schedule. Our consistent and continuous argument has been that we, within the Shiv Sena, represent the rival faction which ought to be recognized as the political party and has now been recognized as the political party in question in this matter. Now, my lords, if your lordships will recollect, and my lord the Chief Justice also put a very pertinent question to me yesterday, that could it be argued by someone to say that because you expressed your dissatisfaction with the government in question or the Chief Minister in question, you would incur the wrath of the 10th schedule ex facie automatically. My lords, your lordships in Yadurappa and those line of judgments have categorically held that merely because a dissent is expressed within the party that we have no faith in the government in power does not mean that you're acting against the political party and you do not incur the wrath of Article 2(1) subclause A. Because till 2nd of July, my lords, 2(1)B does not get triggered. Both the disqualification petitions till 2nd of July 2022 are based on para 2 subclause 1 subclause A, whether you have voluntarily given up the membership of the party or not. And there we have respectfully submitted that time and again your lordships have interpreted it to say that there must be overt specific acts, moving with MPs to say that we are joining someone else, merging with another party. Those are overt acts which are considered. My learned friend cited one judgment where they said in the context to say that withdrawing support would also amount to the same. But please see the series of judgments, what they say. Yadurappa categorically says that merely because you go and say, I have no faith in the Chief Minister. In fact, there it was the Chief Minister. In our case, we don't even say that. Our case was not that we did not have the faith in the then Chief Minister to continue with the government. Our argument was that you cannot continue in the government in an MVA coalition with the NCP and the INC. Because, my lords, our resolution of 21st of June 2022 categorically said that your pre-poll alliance was with the BJP. Your post-poll alliance in this era of competing ideologies is with a person and a party with whom we've had serious differences for decades. And there is a vast discord and discontent amongst the cadres of the political party and the workers of the Shiv Sena. And thus we said that this is a case where there is internal dissent within the party. So right till 2nd of July 2022, it was only a case of 2(1)A. which Yadurappa squarely covers and says that merely because you express internal dissent, which is the essence of democracy, it cannot be treated to mean that you have voluntarily given up the membership of the party under 21A. As far as the whip issue is concerned, my lords, which is a 21B issue, on 21st, there was a whip appointed by us. They reiterate their faith in another whip. Both give their own categorical direction, which only comes into action on,
You appointed your whip
on the 21st of
There was
June.
already an existing whip, right?
No, my lords, there was an existing whip, but when overwhelming legislation, and I'll come to that, my lords, I'll just develop that argument.
So that we are flagging for you to answer, that whip arising out of a legislative party, not the political party, that you answer.
Absolutely, my lords, I have, because that's one of the issues also framed by your lordships, and when I deal with the issues, I'll deal with that as well. But it's important, my lords, let me just revisit some of the timelines, my lords, because a lot has been said on these timelines, and it's important for your lordships to keep in mind these timelines. Just go that one. My lords, it is our contention in the place lock folder.
Yes.
Abhi nahi. May I? Well, it is our contention, and now I'll just go through some of the important dates, just 7 or 8 of them, my lords, to say that the very act of filing a disqualification petition was in fact an attempt to stifle dissent in the party. After a resolution is passed and we express no confidence in the deputy speaker, suddenly a disqualification petition is filed. So our respectful submission is that 10th schedule cannot be used to stifle dissent within the party. And definitely internal dissent does not amount to voluntarily giving up the membership of the party under Article 21A. So, my lords, leading up to the 2019 elections, my lords, there was a pre-poll alliance between the Shiv Sena and the BJP.
So those timelines you're reading from somewhere, or?
My lords, these are just 5-6 dates I jotted down. I'm so sorry. I just jotted the relevant dates.
No problem. You can,
Yes.
Why don't you give us those dates so that we'll first take down those dates and then you can make your submission on that.
Yes.
If you can just give us those dates straight away and then you
Yes.
can make your submission.
I see, my lord. Then what I'll
We can
also
then,
do,
just-
I'll also do by the end of the day, I'll have a page typed out. I should have
No
done. I didn't
problem.
get the.
But you can straight away just 5 dates so we can take it
Yes,
down.
yes,
later.
5 or 6 days, my lords.
Just
So,
tell us those dates.
21/6/2022,
Yes.
22/6/2022.
What happened on 21/6?
Well, I just should I?
Oh, you are giving
No,
it
no, whichever way your lordship
No,
wants.
that's
Should
okay. It's well, what-
I'll go.
Easier to type it out if
Yes.
you say 20.
No, my lords, I must confess, I thought your lordship said first give the dates, then explain what happened.
No.
So
That's what I meant.
I'll just give with the event that happened.
Said,
Yes,
obviously,
yes, I'm very,
that's what. Yeah.
very grateful. So, my lords, on 21st of,
It's easier to type it out.
Yeah.
on 21st June 2022,
Yes.
the first meeting of the majority of the Shinde faction of 34 MLAs takes place. "34 MLAs were present in this. Mr. Gogavale was appointed as the chief whip, and Mr. Prabhu's appointment as the whip was cancelled with immediate effect.
This chief whip was appointed by the legislative party.
Malad, that yes, park it. I'll show to your lordship that this is not only the convention, this has the authority of the political party. So this whole argument that this is only the legislature party and not the political party, I'll demonstrate that. That is how it's been right through. This whole artificial distinction which has been drawn that it is the legislature party who did it and the political party had nothing to do with it. I'll come to it. That's a specific issue.
Let's go through the dates. Give us the dates so that then we can then focus on that.
Yes, my lords. So
dates and event, I mean, whatever.
Date and events, my lords. So on 21st, my lords, Mr. Gogavale is appointed as the chief whip. Mr. Prabhu's appointment as the whip is cancelled with immediate effect. And a resolution is passed which categorically provided that there is enormous discontent amongst the cadres of the party for forming a government with NCP and INC, who are ideologically opposed to the Shiv Sena. The resolution also said that the act of entering into a coalition had a tremendous negative impact on the voters and the party cadres at large, and that there was hue and cry towards the party leaderships for the act of aligning with the opposing parties. And then it categorically says that the MLAs as well as the leaders and workers throughout the country are facing a lot of humiliating questions on this count. So this is what we did. On the same day, the minority faction within the party, which at that stage was 24, now is of course less than 14 or 14, whatever. 24 of them on that day,
on 21st June itself,
met and passed the following resolutions. 1, removing Mr. Shinde as the leader of the party, because Mr. Shinde also had been a leader since 2019 of the legislature party. So they removed Mr. Shinde as the leader of the party and they appointed Mr. Ajay Chaudhary as the leader of the legislature party. The resolution also recognizes Mr. Prabhu as having been appointed as a whip previously. On 21st itself, my lords, a notice was also sent by the majority faction, that is the Shinde faction, for removal of the deputy speaker. This notice was issued on behalf of and signed by 34 MLAs of the Shiv Sena Legislative Party.
Deputy Speaker. Remove him.
So is it not therefore clear that on the 21st, there are two clear factions. One, you claim that, well, there were 34 with you. And the others say that, well, there are 24. The 24 says, look, we are reiterating.
21.
21.
21. It's 55, so it's 21.
Right, 21. Not 24, 21.
21. Now, on 21st itself, the deputy speaker communicates to the minority faction that they have accepted Mr. Ajay Chaudhary as the leader and does not respond to our.
Come again?
On 21st itself,
yes,
the deputy speaker or the undersecretary of the Maharashtra Secretariat communicates to the party that they have appointed Mr. Ajay Chaudhary as requested by the minority faction and does not respond to our communication at all. On 22nd of June 2022, a notice is given by the minority faction to attend an emergency meeting on the same day at 5 p.m. And the notice said if you fail to attend, it will be deemed to indicate your clear intention to voluntarily give up the membership of the party. That's been their only case of voluntarily giving up the membership
To
of the
attend a
party.
meeting on
22nd of June 2022.
same day. Meeting is to be held on?
Malad,
Same day meeting.
yes, on the same day at 5 p.m. At 5 p.m. On the very same day, my lords, on the very same day, the majority faction writes to say that Mr. Prabhu's letter stating, calling for a meeting, he had no authority to call for a meeting, and therefore the notice is invalid, as he had been removed from his position as the chief whip.
No, rights to?
The majority faction replies to Mr. Prabhu's notice because he had called a meeting the same evening of the minority faction. He was part of the minority faction, issued a letter calling for an emergency meeting at 5 p.m. on the same day.
They stated that he had no right to.
Because he had been removed on 21st as the whip by the majority faction. On 23rd June, the first disqualification petition on 23rd June, the first disqualification petition is filed before the Speaker, before the Deputy Speaker against 16 MLAs by Mr. Prabhu on the grounds that they had voluntarily given up the membership of the party to attend the meeting as they did not attend the meeting on 22nd.
First disqualification petition is filed before the Deputy Speaker.
On the grounds,
by Mr. Prabhu, no?
that's right.
That they had voluntarily given up membership.
Was your notice to the speaker for removal of speaker given?
On 21st of June 2022.
So therefore, that's one first date which you have.
Prior in time.
That date hasn't come. So 21st is the notice given by your group for removal of the speaker.
Of the Deputy Speaker. Because there was no speaker for the removal of the Deputy Speaker.
21st itself.
Yes.
So that 21st is cancellation of Prabhu's appointment as a whip and for also the removal of the Deputy Speaker.
It, my lords, has first Mr. Gogavle appointed as the whip.
Right.
Mr. Prabhu cancelled with immediate effect.
Right.
The resolution that there is widespread discontent passed on the same day.
That we took.
And also the separate notice issued to the Deputy Speaker.
Yeah, that you're right.
It's not part of.
Separate notice for removal the Deputy Speaker.
Notice for removal.
Under Article 179C. Fellows, may I? Now on 25th of June 2022, disqualification notices are issued to 16 MLAs by the Deputy Speaker, asking the MLAs to file their replies by 5:30 p.m. on 27th June
Just
2020.
before that, 23rd June, the first disqualification petition is for how many people?
For 16.
16 MLAs.
Okay.
What is their argument?
Yes.
Then the next one was 25th, no, you said?
Yes.
25th.
25th, disqualification notices issued to the 16 MLAs by the Deputy Speaker, asking them to file their replies by 5:30 p.m. on 27/6/2022. And 26th and 27th were the weekend. So these 2 non-working days are given to file a reply.
28th.
26th, 27th. Which one is to call?
25th is when they are given a notice to file their reply by 27th.
By 20.
So intervening are 2 non-working days, which are 26th and 27th are both non-working days. It's the weekend.
Right.
Now, on 25th, it's an important event, my lords. Even the Thackeray faction writes to the Election Commission. Minority faction writes to the Election Commission. So they go to the Election Commission to say that there is a rival faction which may set up a political party. We are the Shiv Sena. They write to the Election Commission, invoke the jurisdiction of the Election Commission. And that order is not the subject matter before your lodges. The EC order which your lodges are dealing in another matter, where I've been recognized as the political party, categorically says that this rival factions had emerged on 21st and maybe was the culmination of dissent for a long time, culminated in the resolution of 21st of June 2022. It is in this background, my lords, that on 27th of June 2022, we come to this honorable court to say that A, there has been a serious violation of principles of natural justice, because instead of the scheduled period of 7 days, a 2-day period over the weekend is provided to us, and we need more time to file a reply. We also argue Nabam, and I've repeatedly said so. I'm not for a minute ever suggested that we did not argue Nabam. We also argue Nabam to say that quite unlike the cases of Quixote, and this was heard at length, where it says that you will not interfere at an interim stage, Nabam, which is much later in time, takes note of it and says, but where there is a petition pending for the very removal of the speaker, it would be constitutionally and ethically not proper for him to continue. He can always, in the meantime, prove his majority on the floor of the House and then continue with the disqualification petitions, because as Justice Mishra in detail said, that no harm is caused. At the earliest prove your majority, you can lay down the timeline, show that you have the confidence and proceed with the disqualification, but the reversal would be disastrous, because you would then set the pool and composition of the House to suit yourself so that no one can remove you in the meantime. And those entire arguments that your lordship had heard on 14 days, 7 days, etc., would be utilized. And that has to be seen, the then members have to be seen in the context of the notice on the date which was given to you. Your conflict of interest starts on that date when the notice is given to you. And you would utilize that time. And this is what Justice Mishra dealt with in that judgment in Nabam, to say that look at the reverse. Nothing happens in the meantime. If you are, tomorrow you win the confidence, you come back and you win the confidence. But as far as the other party is concerned, it's lost an opportunity to vote against you. Now, my lords, after this, it was keeping this in mind, after hearing arguments of this, the court consciously still only extended, did not injunct the speaker, gave time till the 12th. And of course, my lords, we had also in this raised as a justification for coming in an Article 32 to the Supreme Court was that there was a threat to our lives, homes are being burned, and we read out the press statements of Mr. Raut and others and saying that you'll see a series of dead bodies coming, etc. And we said it's not safe for us to go. And that is why we are out of the state. So these were the principal three grounds that we came on. The court consciously on that day said only time is extended because the period provided as per us was 7 days, which was not complied with. On 27th of June 2022, the second disqualification petition is moved, this time against 22 or 22. Against 22 MLAs is filed by Mr. Prabhu.
It's also 27, is it?
27th, 6, 2022.
Yes, how many MLAs?
22.
From the speaker.
Yes, sir, from the record.
Till date, my lord, subject to correction, I'm instructed to say that no notice has been received or was received, unlike in the case of the first 16, by any of the people against whom disqualification was alleged.
Out of these 22.
Against these 22. On 28th of June 2022, leader of the opposition, Mr. Fadnavis, went to meet the governor and requested him to hold a floor test as the coalition ministry had lost the confidence of the House.
Sure. Lord, may I just say one thing on this second, it's very important, for reasons I'll point out later, that as far as the second disqualification is concerned, allegedly on 27, first, as my learned friend pointed out, there was no notice. But for the first time, the disqualification petition of the remaining 22 MLAs is concerned is only on the 8th of July petition. Up to 8th of July, it is never alleged that there was any disqualification petition pending. In fact, in all the governments, as I'll point out when I come to it, in all the governments, in every pleading, it has always been said that there are only 16 MLAs disqualified. On the 8th of July, when they filed a petition in this court, for the first time they alleged that there was a 27th July notice or petition for disqualification of 22 MLAs. Actually, the factual matter is there has never been any disqualification petition, to my knowledge, filed till 8th July.
Now, on
Yes.
28th of June 2022,
That's when the leader of the opposition meets the governor and seeks a
the
floor
leader
test.
of the opposition, yes, meets the governor. My lord, the Chief Justice is absolutely right. And the governor then issues a communication on 28th June 2022 to Mr. Thackeray, directing him to face a floor test on the 30th of June 2022.
So both events of the same day.
Yes. And as I had read out the letter to your lordships yesterday, it specifically refers in detail to three things. One is 7 MLAs who are part of the government, including 2 ministers, withdrawing their support. A letter of the leader of the opposition saying that it has lost its majority, and the resolution of 21/6/2022 passed by 34 of the 55 MLAs saying that there is a huge discontent within the party. And he calls upon Mr. Thackeray to face the floor test on 30th. Now, immediately after that, on 29th of June 2022, Mr. Prabhu files a writ petition before the Supreme Court seeking a stay on the direction calling for the floor test. On the ground that disqualification petitions of 42 MLAs was pending consideration.
That stay is refused by our court on the same.
And my lords, Arguments were heard till late evening, and our contention right through was that how can any chief minister ever say that I will not face a floor test, because your lordship have time and again and said a floor test should brook no delay. It's the litmus test of democracy. A floor test should be held the moment, and the words used in Bomai by your lordships are, the governor as the constitutional authority is entitled by any means or process to, the words used are by any means or process in para 121 to say, to come to a conclusion that this necessitates a floor test. So when your lordships put that question to me yesterday, my respectful submission was that what else is a governor expected to do? He's not concerned with the 10th schedule, legislative party versus political party. His only concern is, does the government enjoy the majority on the floor of the house or not? Now,
Have you completed the dates? These are the.
sorry, I digress. Let me complete the dates.
Just complete the dates so that.
Yes, my lord. So the court then says the floor test of 30th, and categorically only says the floor test of 30th is subject to the outcome of the proceedings. But that floor test on 30th never happens, because on 29th, Mr. Thackeray, within 10 minutes of this stay being refused, resigns as the chief minister. On 30th June 2022, my lords, Mr. Shinde and Mr. Fadnavis approached the governor as a coalition staking claim to form the government. And on 30th, the governor swore in Mr. Shinde as chief minister and Mr. Fadnavis as deputy chief minister, and directed the new coalition to prove its majority on 4/7/2022.
They are sworn in on the 30th itself.
Yes, my lords.
To the majority on the 4th.
Please, on the 4th. This 30th first. Now, on 30th, even the minority faction claims that they sent a letter, which is, as per the Election Commission, received on 1st in their office, again bringing to the notice of the Election Commission, as they did on 25th, a change in organizational setup of the party, including Mr. Shinde's removal as the leader of the legislative party.
Mr. Kaul, will you repeat yourself?
Yes. So, lady, on 30th, even the minority faction claims, which, of course, as per the Election Commission, is a letter received on 1st of July, they write to the Election Commission intimating change in the organizational setup of the party, including Mr. Shinde's removal as a leader of the legislative party. Is not removed as a member of the party, but as the leader of the legislature party, is their letter. The purpose that I'm emphasizing is that both on 25th and 30th, they themselves invoke and go to the EC, knowing very well that for any dispute, intra-party is a dispute exclusively within the jurisdiction of the Election Commission. Now, on 2nd of July 2022, Mr. Prabhu, purportedly acting as a Shiv Sena chief whip, issues a whip to the members of Shiv Sena legislative party regarding the election of the speaker and the confidence motion. As for us, on 21st, he stood removed. He had no authority to issue any such whip. On 2nd, he issues this whip, and this is the first date when their argument of 2(1)(b) of the 10th schedule emerges. Because till now, it's only 2(1)(a), voluntarily giving up the membership of the party by not attending the meeting. On 3rd of July 2022, at 12:01 p.m., Mr. Rahul Narvekar is elected as the Speaker with a total of 164 votes. Charts nikalo. The same day, my lords, at 12:02, I'm going to show the chart. The rival candidate only gets, I'm grateful to my learned friend, gets only 107. At 12:01, Rahul Narvekar is elected as the Speaker with a total of 164 votes. On the same day, on 3rd July 2022, at 12:02 p.m., certain MLAs from the former MVA coalition issues a notice for the removal of Mr. Narvekar as Speaker after him having won his election. And after this, on the 3rd itself, they file a fresh disqualification proceeding against all the 39 MLAs, purportedly for voting against the party whip regarding the election of the Speaker. And this they now allege to 1B. On 3rd itself, my lords, Mr. Narvekar recognizes Mr. Gogavle as the chief whip and Mr. Shinde as the leader of the Shiv Sena party. Which in any case, as per us, on 21st, Mr. Gogavle was appointed and Mr. Shinde, who had been the leader since 2019, we had reiterated our faith in his continuance.
Yes.
Now, they thereafter also challenged Mr. Narvekar's recognition of Mr. Gogavle and Mr. Shinde before the Supreme Court, which is one of the petitions pending before your lordships. And this time on the ground on Navam Rebria, saying that he cannot proceed with the disqualification as there is a petition against him for removal pending. On 4th of July 2022, the House reaffirms its confidence in the newly elected Speaker, Mr. Narvekar. So, my lords, on 3rd he wins. You again move after his winning. 2 minutes later, he again, the House reposes its confidence on the 4th. And on 4th, then, the confidence motion called for on the floor of the House, wherein Mr. Shinde's government proves its majority in the House. 164 for, 99 against. Now, for a minute, my lords, because there's been so much confusion as I'm reading this timeline, please have this chart as well. It's important. Just hand over. My lords, I've had copies made. Sorry, because this otherwise will be an endless exercise on the numbers. Which, where is the second page?
It's behind zoning page.
Lords, I'm so sorry we've printed the. It's typed like this or not?
No.
What is it?
In election.
Second, when Mr. Prabhu issued the press whip.
Yes. Yes, my lord.
2nd July.
Yes.
He issued the press whip.
Yes.
So according to he could not have because his whip was already removed on
Right.
21st June. That was with respect to the election of the speaker as well as the the trust vote on 4-7.
Yes.
Correct. So can it not
And
be
then-
said? No. Can it not be said that by issuing the fresh whip, correct, they have accepted the calling of the trust vote on 4-7?
Yes.
So you can very well,
I'm-
your submission can.
I'm
be
grateful.
there. They cannot challenge.
I'm grateful. I'm grateful.
Subsequent calling the trust vote on 4-7.
I'm grateful.
Otherwise, they would not issue the whip on 4-7.
I'm grateful, my lords. I'm grateful.
On 2nd
Lordships
July.
are right. Lordships are right. I'm grateful.
But just we wanted, at least I wanted to know that it was with respect to both speaker election.
Yes,
as well
yes,
as
yes,
no
yes, my lords. Yes.
trust vote.
Yes. Now, my lords, kindly have this chart. Now, first, my lords, is the election of the speaker, Mr. Rahul Narvekar, on 3rd of July, 2022. My lords, has that?
Yes.
Now, please see, this is, I've done the exercise, my lords, both with 42 and without 42. I've done both the exercises on both the speaker and the confidence. So first it says, my lords, voting in the election of the speaker so-and-so, including the 42 members against whom disqualification petition was pending. Now, please see, my lords, Shiv Sena 39, BJP 105, others 20, total votes received by Mr. Rahul Narvekar 164, total votes against Rahul Narvekar 107, absent members 16, total strength of the House 287, strength minus the abstain is 271, majority mark 136, votes secured by Speaker 164. Now please have the one, my lord, where we remove the 42. Shiv Sena 0, BJP 105, others 17, total votes received by Rahul Narvekar 122, that is 164 minus 42, total votes against Rahul Narvekar 107, absent 16, total strength 245, strength minus abstain 229, majority mark 115, votes obtained 122. Now please have, my lords, on the back of the page, voting on in the floor test of the government on 4/7/2022, including 42 members against whom disqualification petitions were pending. Shiv Sena 39, BJP 105, others 20, votes in favor of Eknath Shinde 164, votes against Mr. Eknath Shinde 99, abstain 24, total strength 287, strength minus abstain votes 263, majority mark 132, majority votes obtained by Eknath Shinde 164, against 107. Now kindly have where 142 are removed. Shiv Sena, so BJP 105, others 20, votes in favor of Eknath Shinde 122, votes against Eknath Shinde 99, abstain 24, total strength 245, strength minus abstain votes 221, majority mark 111, votes secured by Mr. Shinde, discounting 42 MLAs is 122. Now, my lords, I'll come to the issues and I'll proceed issue-wise, my lords, because I have to deal with, as my lords have said, not only each of those issues, but also the issue of legislature party versus political party. But my lords, just before that, there is one submission that I wanted to make, which is we are dealing with three constitutional authorities, my lords. An attempt is to confuse issues as far as the exclusive jurisdiction of each of the three is concerned. The governor, all that he is concerned with is, do you in a democracy have the confidence of the House or not? Now, what better way to test that confidence than a floor test? Having said that, I'm not for a minute suggesting that it's not subject to judicial review, or you can just ask for a floor test for the asking, and there has to be material, there has to be due application of mind. But when an overwhelming number of MLAs write to you for various reasons and say that the concerned government or the ministry does not enjoy confidence, what is wrong with the governor having taken the decision of just given the opportunity to the then chief minister to face a floor test. In fact, rather than dissolving or sending a report to the governor, an act which the Supreme Court repeatedly frowned upon by saying that there used to be a huge misuse of Article 356, where reports to the president were said dissolving the House. They said the first thing is let them face the floor test. What is wrong with it? That is one. Secondly, my lords, comes the issue of the Election Commission. The Election Commission under the Symbols Order decides on what the words used are splinter group stroke rival faction. Those are the words used in para 15 of the Symbols Order. This whole argument that I have split, I have not merged, is not my argument at all. I have never claimed a split. I am claiming a rival fraction within the party, which according to us represents the Shiv Sena and has now been recognized as the Shiv Sena. Because your lodges have held that ultimately when two rival factions emerge within a party, you can't recognize both, is what your lodges judgments have held, because a symbol can't be split into two. A name can't be split into two. It ultimately has to go to one or the other rival faction. In this case, that's a separate petition, but the competent body has decided to say that I represent the rival faction which should be recognized as the political party. And that's a decision exclusively vested in the Election Commission, Sadiq Ali downwards, including on interim orders, including on deciding whether political majority, legislative majority, two to be taken together, what's the cutoff date, when disputes have arisen, what numbers will be seen. They say they're the only party, only body entitled to and equipped to deal with it. And
Mr. Kaul, for the purposes of the 10th schedule, it makes no difference as to whether the rival faction which has emerged claims to still be within the fold of the erstwhile political party or forms a new political party in the legislature. It makes no difference at all. Once the 10th schedule, the 10th schedule attaches a disqualification the moment you have a rival faction, unless you make out one of the defenses. And it makes absolutely no difference whether you are saying that, well, we are in the same party. We are only saying that we represent the same party. Here, all the dates you have given us make it very clear that there is a rival faction. From the 21st, 34 MLAs represent a rival faction. They say, well, we are the Shiv Sena. There was a great deal of discontent because you teamed up with the Indian National Congress and the NCP when you were ideologically opposed to them, that we had a pre-poll alliance with the BJP. Fair enough. That's their contention. But does that obviate the fact that this is a rival faction within the meaning of the 10th schedule and a split within the meaning of the 10th schedule?
I was just coming to that. That's why I said three different authorities, three different provisions. I'm not for a minute suggesting that 10th schedule has a bearing there at all as far as the Election Commission is concerned. The third issue I'll just touch on, my lord.
And you know, a split does not postulate that people who are party to a split leave the party. It may be that the people who split sometimes leave the party. But otherwise, the 10th schedule will also operate where a group of persons, whether minority or majority, say that we belong to the same party.
Yes, my lord.
And though you've constantly said that, you know, the Eknath Shinde faction was the majority and the Uddhav Thackeray faction represented a minority after the 21st, it makes no difference to the application of the 10th schedule as to whether who remains is in the minority.
Yes. Manoj, I'll now answer that. So one, my lords, the governor, as far as the floor test, the Election Commission, which looks at everything, including the legislature party, the political party, which according to us are integral. You can't segregate them, and comes to a conclusion which rival faction or splinter group should be recognized as the party. Then comes the issue of the scope of 10th schedule. Now, my lords, as far as the 10th schedule is concerned, an attempt is being made to place before your lordships to say that this was only the legislature party, this was not the political party. And in 2(1)(b), what is mentioned is the political party and not the legislature party. And in Mayawati, your lordship said that it is not the legislature party, it's the political party, which is mentioned in 2(1)(b), and it can only be read as the political party. This is what your lordships are told. Now, my lords, I have never ever said that the two are different. Our argument right through has been that this decision of the legislature party has the authority of the political party, And the only interaction that a speaker has while deciding on whether 21B has been violated or not is his interaction with the leader of the legislature party and the whip appointed. Because conventions have also shown, and I'll come to those specific Maharashtra Assembly rules have not been shown to your lordships. The members of the legislature party appoint the leader of the legislature party. The leader in turn informs the speaker about all posts, all designations, which necessarily implies also about the whip who's appointed and any change in that. Even when the defense of para 3 existed, when the defense of para 3 existed, there were only two defenses, para 3 and merger in 4. Even when the defense of para 3 and split existed, the Supreme Court in Rana said that the speaker cannot embark on any independent inquiry as to what has happened within the political party in a split within. He will only, for purposes of disqualification, take a prima facie view. In any case, that is today academic because para 3 is gone. Now, what will the speaker today look at? The speaker under 21B will look at who has issued the whip. What is the direction? Now, as for us, the whip as on 21st is not Mr. Prabhu. And we are not obliged to follow any direction of his. We are not for a minute suggesting, in fact, our contention has been that the speaker cannot determine. Your lordships are absolutely right. The speaker under 10th schedule is not required to go and determine whether a political party is split or not. That is the EC's jurisdiction. All that they look at is which are the set modes. The set mode is a speaker doesn't embark on finding out in the lakhs of membership who is the political party, who was expelled, who was not expelled. His interaction is with the essentially the legislature party. Now the problem which comes in the argument of the other side is to say, no, the word mentioned is political party, and since the two are separate, you are only relying on the legislature party. That's not our argument. The symbols order para 6 and 6A categorically provides that even for the continued recognition of a political party, its vote percentage, its elected representatives, its elected members of parliament are all important to determine the existence and continuance of a political party. So when you say this is legislature, this is political, that's an artificial distinction you are drawing. According to us, that legislature party has the political authority of the political party. And that has been the convention right through. And I'll show two letters. One is on record, one is not. Every time that a whip is communicated to the speaker, it's the legislature party which communicates the whip to the speaker. So this argument which is sought to be made is, and Mayawati said it's only the political party, you are the legislature party, thus you've incurred the wrath of 21B.
This is the rules of the Maharashtra legislature.
Yes, my lord. I'm very grateful for that. I'm very grateful.
Those rules are very, very important.
Yes, yes. Show me. Statute compilation, my lords, on
PDF page 4,
PDF page 4,
starting at 6.
starting at 6. Rule 2F.
Yes, sir. 2.
Right. And then I'll go to 15 and 6A and 6B later.
Page 4, compilation 1, page 6.
First compilation?
Statute
First compilation,
First.
yes, statutes.
Page?
PDF page 6.
What page?
PDF page 6, my lord.
6.
This contains the entire rules or only part of them?
The entire rules.
Because these are the entire rules, I'm told.
Yes, the entire disqualification.
You filed the entire rules?
Yes, entire disqualification rules.
Yes, yes. The disqualification rules, my lords.
Are these rules?
Because they were framed under para 8 of the 10th schedule.
Yes, PDF. Starts there. Statute.
First, my lords, 2 subclause G,
Page 7.
page 7, my lords. Then I'll go to the earlier section, but first have 2 subclause G,
Member.
page 7. Member means, my lords, has that? Member means a member of the Maharashtra Legislative Assembly. It says nothing else. Now please have 2 subclause F. Leader in relation to a legislature party means a member of the party chosen by it as its leader and includes any other member of the party authorized by the party to act in the absence of the leader as or discharge the functions of the leader of the party for purposes of these rules. And now kindly have Rule 3, subclause 1. My lords, have Rule 3, subclause 1. May I, my lords?
Yes.
My Lord the Chief Justice, may I? Rule 3, information to be furnished by leader of a legislature party. The leader of each legislature party, other than the legislature party consisting of only one member, shall within 30 days after the first sitting of the House, or where such legislature party is formed after the first sitting, within 30 days after its formation, or in either case within such further period as the Speaker may for sufficient cause allow, furnish the following to the Speaker, namely, a statement in writing containing the names of the members of such legislature party, together with other particulars regarding such members as in Form 1 and names of designations of the members of such party who have been authorized by it for communicating with Speaker for purposes of the rules. And now kindly have Rule 3, subclause 4. Page 8. Whenever any change takes place in the information furnished by the leader of the legislature party under sub-rule 1 or by a member under sub-rule 2, he shall, as soon as may thereafter, and in any case within 30 days from the date on which such change takes place, or within such further period as the Speaker may, for sufficient cause allow, furnish in writing information to the Speaker with respect to such change. So it's the leader of the legislature party who communicates, points out the designations, the posts, and the people who are appointed. And today, clearly within, 2 rival factions are claiming that their leader is the leader of the legislature party and the whip. Now, the Speaker at this stage, my lords, only goes by what the leader communicates. The Speaker, as your lordships have held, has no independent tools at his disposal to go and find out within a political party where lakhs of taluka, district level, party organizations, members, constitutions are involved. That is how he interacts. Now they attempt to get out of it by saying that you only had a meeting of 34 legislatures, so thus you're only the legislature party. So our contention says who? You decide on your own that I am disqualified under 2(1)A, you decide I am disqualified under 2(1)B, and without a speaker deciding on either of the two. And you tell the court that this is ex facie evident that you have lost your membership, you're hit by the 10th schedule, and so you should be declared disqualified.
So this Form 1 should include whip also?
Manoj, I'm not too sure whether it does.
All posts. All posts.
It does. It does. It does. It
Normally does by
Yeah, it does. It does. It does. Such members as in Form 1 and names and designations of members who have been authorized.
Who have been authorized by it for
Communicating with the Speaker. So which includes, my lords, communicating in any form. including the views. Now please see.
Yes, the communication,
The two communications.
it talks about the speaker for the purpose of these rules. These rules also relate to
Qualification.
the,
3-5 is also.
no, it is called intent.
My lords, now I have 3 subclause 5, where a member belonging to any political party votes or abstains from voting in the assembly contrary to any direction issued by such political party or by any person or authority authorized by it in this behalf without obtaining in either case the prior permission of such political party, a person or authority, the leader of the legislature party concerned, or where such member is the leader or as the case may be the sole member of such legislature party, such member shall as soon as may be thereafter, and in any case within 30 days from the date of such voting or abstention, inform the speaker as informed to whether such voting or abstention has or has not been condoned by such political party, person or authority. But today the limited issue before your lordships as far as the 10th schedule is, how does the speaker determine it? They want today the speaker to embark upon and decide what the EC is meant to decide. The legislature party, the political party, according to us, are not distinct. They are co-joint, integral, and organically connected with each other. That is,
The bar who's not gone paperless. So
well, may I with respect say, from the day this hearing has started, I've been praying that your lordships doesn't ask me this question. But finally, it was inevitable and it is followed on me today. But your lordships can be reassured, I'm trying very hard. And I have this with me and I'm taking some classes and lessons in it, my lords. Give me some time, hopefully I'll be there.
before the next CB.
For sure, my lords. For sure.
Fortunately, the Bar Council group don't contemplate disqualification.
your other two colleagues have coped up.
Yes, yes, my lords. They are far,
Mr. Sib-
far more able, my lords.
You have.
We've acted as
hours. I
Chief
put in some
Justice.
extra hours to learn. And what is now
My lords, but in all fairness, I've read out a few judgments from this to your lordships. In fairness and in my defense, my lords, I've read out at least a few judgments from
all the navigation
in other
is being
matters,
done
he has
by-
no defense.
The navigation is the navigation is being done by your junior. You have to also do the navigation yourself. That's also the essence of being paperless. You see,
My lords, your time is precious. If I start doing the navigation at the moment.
all right.
So if that is the layout, please see how have parties understood these rules in terms of communicating to the speaker. Now,
You also can, if you can show us some kind of a practice which has been followed.
yes, that's what I'm coming to. Yes, my lord, that's exactly what I'm coming to. So please immediately now have
This, Mr. Kaul, this only answers half of the contentions raised by the other side, only to show that these names will be forwarded by the leader of the house to the speaker.
yes. No, my lords, absolutely. When I deal with the issue, my lords, I'll deal with it squarely. Since the question fell from my lords, I just attempted to. Just give. Have you got the letters?
Yes, sir.
Have you got the letters? Given it? My lords, one letter is on record. This other letter I don't think is on record, my lords. We've just got copies made. And give one to the other, to the other side as well. Have you given to the other side?
No, just wait.
Yes.
Just.
Yes, Courtmaster, if there's an extra copy, could you return it? I need to give it to the other side.
Thank you.
Very grateful. Now, my lords, as late or recent as 6 July 2022, Mr. Sanjay Rao, as leader of the Shiv Sena parliamentary party, writes to the speaker to say, this is to inform you that Shiv Sena parliamentary party has nominated so-and-so as the chief whip in Lok Sabha in place of Srimati Bhavna Gavli MP with immediate effect. And also, my lords, the earlier letter, which is
Convenience compilation.
Convenience Compilation Volume 2,
Yes, 728.
PDF 728,
Yes. Convenience.
PDF 728,
Which comparison?
Volume 2.
Volume 2,
Page? 7 to 8.
PDF page 728.
That letter of 25th of November 19, Mr. Bal,
Yes.
Yes, my lady.
which is already highlighted.
Yes, it was read out, but I now want to read it in the context of the rules. May I, with your lordship's permission?
Yes.
To the Honorable Speaker, Shiv Sena's newly elected MLAs meeting was convened at Shiv Sena Bhavan, Dadar, Mumbai on Wednesday, 31st/10/2019. The meeting was chaired by Shri Uddhav Thackeray, Shiv Sena Paksh Pramukh. All the newly elected MLAs of the Shiv Sena party unanimously resolved that all the decisions of today's meeting be decided by Shri Uddhav Thackeray and authorize Uddhav Thackeray to take all the decisions in the meeting. Thus, Shri Eknath Shinde and Shri Sunil Prabhu were appointed as group leader and chief whip of the Shiv Sena legislature party in the Maharashtra Legislature Assembly. The resolution passed in this regard as follows. Resolution 1. It is resolved in the newly elected MLAs meeting of Shiv Sena party that Shri Eknath Shinde is appointed as the group leader of the Shiv Sena legislature party in the legislature. It is resolved in the newly elected MLAs meeting of the Shiv Sena party that Shri Sunil Prabhu is appointed as the chief whip of the Shiv Sena legislature party, and then all the MLAs.
Who writes this?
This doesn't have a,
This is signed by all the MLAs.
but it has the signature of all the MLAs.
So it's collectively written.
Collectively written, I'm grateful, by all the MLAs. And that is why I said, my lords, to that question, that when we come under the 10th schedule, what you're seeking to do is today create a distinction which does not exist. We have never argued the legislature party is separate or the party under the 10th schedule 2(1) means only the legislature party and doesn't mean the political party. That's not our argument. It's always done through the legislature party, at least in majority of cases, my lords. It's never the party president who writes to the speaker.
The call. Please read one of that, this communication, one.
Shiv Sena's newly elected.
Yes. Shiv Sena's
Newly elected MLA's meeting was convened at the Shiv Sena Bhavan, Mumbai. The meeting was chaired by so-and-so Shiv Sena Paksh Pramukh.
Correct?
Right.
Now these 4 lines are very important.
Paksh Pramukh.
Because what was the resolution passed? It is only a communication, correct, of the resolution passed, correct? It was a communication.
Yes.
Correct? It is not that the leader is decided by the legislative party. Please read the next resolution.
All the newly
The
elected.
meeting was chaired by so-and-so, so-and-so. All the newly elected members of so-and-so unanimously resolved that all the decisions of today's meeting be decided by so-and-so, so-and-so.
But they authorize it.
My lords, I have right through said the legislature party has the authority of the political party to do so. I am not for a minute suggesting that that is not so. They have the authority to do so. The communication is through the legislature party and the speaker's interaction is through them. Doesn't mean the political party is not involved.
Naturally, the decision is always communicated, whatever is only by the legislative
Yes.
party and or the leader of the
Yes,
legislative party.
yes. Yes, that's all that I'm saying. Now, my lords, let me straight away now.
Exactly. Somebody has
Otherwise,
to-
who will communicate?
Yes. Yes.
For the speaker is concerned, it is only the leader of the legislative party will communicate.
Absolutely. Now, my lords, when I come to the case law and distinguishing case laws, once I'm through with the rules, I'll distinguish Mayawati. Mayawati is in a completely different context, and I'll deal with that. Rana, Mayawati, all those line of judgment cited, I'll distinguish each one of them. But let me now, my lords, at least start with the issues at hand, which have been referred to your lordships. Let's kindly come first to the second issue, because Nabam, your lordships have heard arguments at length. On Nabam, your lordships have heard arguments at length, and I needn't trouble your lordships again until unless called upon. Please have issue B, and I'll go issue wise and deal with
B.
yes.
Where are you reading B from?
What are you reading?
Well, that can be
Where are
read
they?
from that order as well. I'll have
Oh, that's
order.
the earliest order.
Yes, yes. I'll just give it. I should have actually pointed
Okay,
that out.
okay.
Order
Yes, the
compilation.
referral order is, my lords,
An order compilation.
23rd of August 2022.
It's there in the
Orders compilation.
orders compilation.
My lords, orders compilation, PDF page 34.
Yes. What's the meaning of should be inviting a decision?
That's the question. May I read out?
Yeah.
My lord the Chief.
Yes.
Whether a petition under Article 226 or Article 32 lies inviting a decision on a disqualification petition by the High Courts or the Supreme Courts, as the case may be. Now, my lords, our respectful submission is
Lies inviting a decision.
possibly a direct. My lord, I think the inference was that could your lordships directly decide it?
Well, yeah, that's right.
That is
Whether
my.
we can directly decide what the
Yes.
speaker should have decided.
Yes, yes. So, my lords, on that, our respectful submission is that this is in the teeth, the argument of the petitioner is in the teeth of Quixote, because ultimately, my lords, under the Constitution, para 6 of the 10th schedule, the speaker is the sole constitutional authority to decide the issue of disqualification. It is the constitutionally designated authority to decide the issue. And even the proceedings before the speaker have been stated by your lordships to be proceedings under 122 and 212 as proceedings of the House. And even the interference with such decisions, except for violations of fundamental rights or substantive or gross illegality of unconstitutionality, etc., ordinarily is not interfered, but not to say that it cannot be challenged. I'm not for a minute saying it cannot be challenged. Now, what your lordships are being asked to do is to bypass the entire constitutional machinery, not only for the speaker. Even earlier, an attempt was made as far as the Election Commission was concerned, which your lordships refused to grant stay and said, let the Election Commission take a stand on it, and then let the petition come here. And that is why at that stage I had submitted that your lordship can't act as the court of first instance. These are coordinate constitutional authorities vested with exclusive and sole jurisdictions. Their decision attains a finality. Their decision attains a finality. These are restricted grounds of challenge. You can't today come to the Supreme Court and say the Supreme Court should decide this issue because according to you, these are extraordinary circumstances. And the entire machinery should be bypassed. So you decide I'm ex facie, I've incurred the wrath of 21A and 21B. The speaker is biased, nothing else remains to be decided, and thus under Article 32, the Supreme Court of India must act as the court of first instance. That is effectively what your lordships are being told in this matter to do. And which, my respectful submission is, my lords, that quite apart from the Shriman Bala Saheb Patil case, where your lordships also held that ordinarily go in a 226 and then come to this court. That's another facet. But in any case, definitely not straight to any court, whether 226 or 32, and say that you decided as the court of first instance. Now, my lords, the same party also relies on Nabam when it suits them. But the reason we came in a 32 that's important today, my lords, is we came in a 32 because Quixote does not deal with the issue we canvassed, which is in Nabam, which is post-Quixote, where a 5 judges bench of this court, and which today still holds the field, says that it would be improper and inadvisable for a speaker to proceed, continue, or conclude a disqualification petition while his own disqualification is pending. It is for this reason that we came in a 32 to say that A, our lives were in danger, we couldn't go to Maharashtra. B, the speaker cannot assume jurisdiction. So to say that we are hit by Quixote, we were not hit by Quixote, and that's the distinction we drew. Whereas your contention is clearly hit by Quixote. Because in your case, you're wanting the court to do something without the speaker even exercising its jurisdiction on the matter. Secondly, my lords, the speaker has won the confidence once. The House has again reaffirmed its faith. And we keep going back to the same argument to say that if that disqualification had been decided, then it would go back to the date what Justice Shah put to me yesterday. And I'll come to that argument. Well, even if a disqualification relates back to the date of the events, doesn't mean any action taken in the meantime gets annulled. In Rana, what your lordship said that when the speaker decides, he only looks at the events on the day the disqualification petition was moved, and at no event post that. That's what Rana said. But those series of judgments that your lordships have given on the point that there is no bar to an MLA or an MP till his disqualification petition is decided from participating in the proceedings of the House, because a constituency can't go unrepresented. He has to be there. Can't mean that all those decisions will be annulled, because the arguments ought to be raised that in the process, the trust vote, everything else will get annulled, and thus your lordships should restore status quo ante, because your lordships created and order created and toppled the government. That's the argument being made to your lordships. My respectful submission, my lords, is it's legally and constitutionally an unsustainable proposition. It's an unstatable proposition in law.
Qualification under the Constitution is vested in the governor.
Please, my lord.
Who takes issues of disqualification are vested in the governor, and he, if he chooses, takes the advice of the Election Commission.
Yes, that's 191(1).
Also, yeah.
And 191(2), as your lordship rightly said, is the speaker.
No, 192 talks about.
Yes.
It takes within its sweep.
Yes, my lords are absolutely right.
If any
Your lordships are
arises
absolutely
as to
right.
whether a member of the House clause 191(1), it will be referred to the governor.
Yes,
Governor takes
yes,
it.
yes.
In any event, decision of the speaker, the judicial review is only decision-making process, but asking the court to decide what the speaker is to decide is a leap.
Yes. Yes, ma'am. Absolutely. I'm grateful. I'm very grateful. Now, Manoj, would your lordships be kind enough to now move to the next question? can a court hold that a member is deemed to be disqualified by virtue of his or her actions absent a decision by the speaker? Because my respectful submission is, how can the court ever deem an MLA to be disqualified pending a decision? Would that not necessarily circumvent the entire constitutional authority, my lords? And would the functioning of the legislature not be put in jeopardy by imposing temporary disqualifications? And would it not hamper electoral democracy that a whole constituency goes unrepresented? Especially when your lordships have time and again held that he is entitled to participate pending his disqualification. And it is sought to be argued that he should be deemed to be disqualified. Without the speaker exercising his jurisdiction or the governor in consultation with the election commission under 191(1) or 191(2), how can the court say that an MLA or an elected representative of the people is deemed to be disqualified till the decision is taken? It's like annulling the mandate of the people, my lords, and by the Supreme Court as the court of first instance in an interim order. Would your lordships be kind enough to have the next question? May I, my lords, with your lordships' permission?
Yes.
What is the status of the proceedings in the House during the pendency of disqualification petitions against the members? Now, my lords, right from Kuldeep Bishnoi, Pratap Gowda Patil, Shivraj Chauhan, and Navam Rebia, your lordships have time and again said that pending disqualification, he participates with all the vigor and robustness and legality as his command in the proceedings of the House. There is nothing which disentitles him from participating in the proceedings of the House. And can it be said that tomorrow, if he is disqualified, all those proceedings that he participated in
Article 100.
are null and void? Suppose there were decisions by his vote, a decision turned. So that will be annulled. Enough in this context to have Article 189 for a minute.
189 and 100 go together.
Yes. So, my lords, 189 is the mirror.
Assembly.
Great, great.
That's what I was saying.